I'm a partner at Sussman Godfrey. I represent both rights holders and platforms in intellectual property litigation, both patent and copyright. Um, and I've been involved in either of those capacities in connection with AI for quite some time. I started working with it in the patent space, and I had a very formative experience early on in the connection with fitness tracker litigation, where a data scientist took me all the way down to the bottom of a machine learning tree of a device that was supposed to detect whether you were sleeping or not. And the remarkable thing was when you got down to all the parameters of the accelerometer that went through this tree, there is no way to sort of conceptually come back and say, okay, now I understand why this thinks this is a sleep state and this is a wakeful state. What's going on under the hood in the machine learning model is doesn't map in any way to our conceptual model of what's really going on. And so I, from that time forward, I worked with a lot of people who were in this space, including Oren Etzioni, who was CEO of Allen Artificial Intelligence Institute, formerly the University of Washington, who is, I think, an AI skeptic and has become a friend and someone who I've had conversations about with this over the years. And I sort of became a person who took the view that the current models and the current technological trends are just never going to get us to what we would really consider to be general artificial intelligence. We will be asymptotically approaching something that seems to be more and more like what a human being can do and create things that seem more and more like what human beings create. But underneath, it's still just a bunch of code that has no real mapping onto the types of processes by which actual humans really create creative work product. But the real difference that we've seen recently, and I think the hype curve, the reason we are around the hype curve is with these incredibly large parameter models, things have finally gotten good enough that at least for some uses, the outputs of these artificial intelligence models are starting to look like things that could be used for commercial purposes. It could be used for a stock photo, could be used for an advertising jingle, could be used to write a simple news story. It's not going to get you that investigative piece in the New Yorker. It's not going to get you that artistic photograph that's going to be on the cover of the magazine. But it's going to be good enough for a lot of workmanlike uses for which rights holders have traditionally been paid. And so predictably, that means that the first wave of litigation has emerged over whether rights holders should be paid and whether rights holders could be paid. And the real core issue, the one that is the headline issue, is obviously fair use. And fair use, legally, there's a multi-factor test, but really what it always boils down to is balancing the value, the value of the new technology to society in general with the cost to the people whose work is being used to create it. And it's incredibly difficult, and the problem is very difficult to address in the case of these large parameter models, because the volume of the data that is needed to create these models in the first place is enormous. It is just simply not practical for a creator of a model that has these sorts of capabilities to go and obtain the rights for all of the works that are used to train it, or at least that's the position that is taken in favor of the argument that this should be fair use. And this position is taken by prominent scholars. For example, Mark Lemley wrote a very influential article called Fair Learning that generally takes this view, but it also has a caveat, and this is also, I think, a widely recognized caveat, even among the sort of the techno-utopians, is that when the output of the AI is really a close commercial substitute for the input, that really sort of changes the balance. And certainly that really seems to be the case, for example, when Microsoft is putting features in Office that allow you to choose whether to license a stock image or whether to generate one with OpenAI, with DALL-E 2. And so the litigation that there's a couple of suits that have been filed they're in Northern District of California. predictably, and they're joining this issue, and we're going to find out how it plays out. One suit involves illustrators, another one involves coders. But beyond the fair use issue, there are technical issues that are going to get litigated here that are going to be very important. The actual mechanics of how these models are created necessarily involves copying, but with the speed with which computers operate, that copying can often be very ephemeral. And it turns out that the circuit courts of the United States have a different view of how long a copy has to be in existence before it's actually fixed in a tangible medium. There are requirements that it be a non-transitory duration, and also that it be capable of being retrieved and read from the medium. And the Ninth Circuit has basically collapsed those requirements, and the Second Circuit has said no, they're distinct, and at about 2 seconds is sort of the non-transitory duration, a decision that was made when computers were much slower. So we're going to see these issues hopefully resolved in a way that gives people some predictability. There's issues apart from copying. There's whether the AI models or the encoders that are used to create some of the inputs for the models, which are themselves trained on large data sets, are derivative works, whether the outputs of the models are derivative work. The issues with respect to derivative works are very difficult because there's issues about the quantity of what is used, and there's also issues about what the quality of what is used. What in order for something to be a derivative work, what is incorporated in the derivative needs to be the copyrightable content. And some people will argue that what these models do is essentially abstract out from all the particulars the general, the savoir faire, the content that is universal and is not itself copyrightable. But on the other hand, when you can put as a text input to a generative model, do this in the style of so-and-so, and it does it in the style of so-and-so, that sort of seems to refute the notion that all you're really doing is extracting the general from the particular. There are issues with how do you protect your rights when how do you, if you are, and this is an issue that I think is confronted the stock industry generally, and registration of works, registration in databases, what the consequences of that for statutory damages. These are all issues that are up in the air. And are there efficient ways for rights holders to protect the inputs when huge volumes of data are being scraped in order to create these models? Are there efficient ways to register works so that you're in a position to actually enforce your rights? There are issues relating to standing and who is a proper plaintiff. In the code case, which involves the GitHub code copilot, there are issues when you're licensing code under the GPL. What's your harm that when this code is incorporated into allowing people to then generate additional code? I mean, isn't that what you originally released it for? And then there are questions about how do you even identify whose works have been infringed? In the case of Stable Diffusion, where they use the Lion data set, which is one where you can actually see the works that were scraped, that's one thing. You can actually check and see, was my work used to generate this AI model? But in the case of OpenAI, that's you can't go and look at the data set. It's not a published data set. Are there ways to actually determine that your particular work was used to create this model? Maybe if you can do in the style of my work and you see it comes out looking like your work, you've got a pretty good idea. But if you're in the stock photography business, how do you put in a description of a stock image and see something that looks like a stock image that you have, but be able to infer that this was your image that was used there are tools. I think in the chat said that there are some tools that people have been developing to try and reverse engineer this. But there are motions to dismiss pending in these suits claiming you can't show that we used your work. And then finally, not finally, but the one other sort of issue I want to flag that we can have for discussion is the balancing of equities involved. Is a single work enough to So do you really need to have a class of masses of people involved to really say that this should be enjoined, and that you need to retrain your model with only licensed content? So these are all the issues that are just now getting teed up in the very earliest stages of this litigation. I've been following it for both rights holder and platform clients, and have been doing consulting work. I'm not currently involved in litigation myself, and I'm trying to take a balanced view of things.